National Working Committee of our great party, after a thorough examination of all the issues relating to the miscarriage of justice by the Supreme Court on the IMO State governorship election petition, and after a very extensive consultation, resolves as follows: that the Supreme Court, as presently constituted under Justice Mohammed Tanko, has become heavily compromised, lost its credibility, and now annexed to execute the ignorable agenda of the APC-led federal government against the people of Nigeria. That the judgment of the Supreme Court voiding the lawful election of Honorable Emeka Ihedioha, who scored 276,404 and awarding fictitious votes to declare Hope Uzodinma of the APC, who scored 96,458 as a governor of Imo State, is highly irrational, unfounded, a provocative product of executive manipulation, and a recipe for crisis which we don't pray for, which should not be allowed to stand.
The PDP yesterday used language that even people who are partially mad in a democracy are not expected to use. We watch as PDP make very, very reckless statements that are designed not only to intimidate the judiciary, but one that is calculated to lay foundation for carefully planned unrest with a view to undermining the peace and stability of the Nigerian nation. But first, we have a duty to state the facts as we understand them. Even though we are not lawyers, reading through the judgment of the Supreme Court, and even based on the fact with which we approach the Supreme Court, I just need to recall what the facts are, to show that PDP is not only reckless, they believe it is their birthright to continue to benefit from electoral fraud and electoral manipulation. Truth be told, by the time the IMO governorship election was conducted and Emeka Ihedioha was declared the winner, you do not have to be a law student of even 100 level. Every Nigerian knows that it is a constitutional requirement, not even an act of parliament. It is not in the Electoral Act. The Nigeria Constitution over the ages and the current one state clearly, and the courts are bound to interpret law according to the Constitution, whereas the courts can bend laws or nullify laws to the extent that they are inconsistent with the Constitution of Nigeria. No court of the land has power to bend, amend, or twist the extant provisions in the Nigeria Constitution of 1999 as amended. In that Constitution, it is clearly stated that to win the governorship seat of a state, a candidate must not only score the highest vote, valid vote in that election, every candidate must necessarily have 2/3 of the local government areas. You must win 1/4 of the votes in at least 2/3 of the states for you to be qualified to be declared elected in a governorship election in each of the 36 states of the Federation. In the case of Mr. Emeka Ihedioha, and I invite you to ask INEC to make available to you because election results are not classified state matters. They are not security instruments. They are valuable, and citizens are entitled to ask and be given those results. Don't take the one from us, take the one from INEC. It shows clearly that even at the time Ihedioha was declared the governor, no attempt was made to disguise the fact that he did not score 1/4 of the vote cast in 2/3 of the local governments in Imo State. As far as we know, Imo has 27 local government areas, and Emeka Ihedioha scored 2/3 of the vote in only 12 local government. 2/3 of 27 is 18. So you have a huge deficit of 6 local government areas, which Ihedioha or any other person must necessarily have to be able to be declared as the winner of a governorship election. This deficit, the INEC, the collating officer, a professor of mathematics, curiously did not know that 12 is not 2/3 of 27 local government areas. He proceeded recklessly to unlawfully declare Emeka Ihedioha as the governor of Edo State, of Imo State.
With the verdict of the Supreme Court executed a coup against the PDP and the people of Imo State, as well as other Nigerians, and as such must not be allowed to have a place in our democracy. The questions Justice Tanko's Supreme Court must answer are: 1. The Supreme Court, in a host of cases, the latest and most celebrated being Atiku versus Buhari and Co., consistently decided that for a petitioner to succeed in an allegation of infraction of any provision of the Electoral Act, especially one complaining about malpractices, as in this case, wrongful exclusion of votes, the petitioner must call witnesses polling unit by polling unit. The question is, how many witnesses did Uzodinma APC call for the 388 polling units from where the Supreme Court allocated votes to him? The so-called results from the 388 polling units were rightfully rejected in line with several decisions of the Supreme Court by the Tribunal and Court of Appeal, as it was merely dumped on the Tribunal in a Ghana must go back by a policeman who had no mandate of the police to testify at the Tribunal. The Tribunal did not even open the Ghana must go back, as there was no basis to do so.
But we fully understand that it has been the philosophy of PDP, particularly from 2003, after the 1999 election, to arrogantly ask their agents or activists and manipulate INEC to ask them to declare results of election, and arrogantly tell the winner, who would have been declared the loser, to go to court and challenge the result if he's not ready to accept the fraud perpetrated, usually between INEC and PDP. That was exactly what they did in the case of IMO. And I think that was the height of irresponsibility on the part of INEC to condone what has been done. Now, we understand that the officer responsible for this is not necessarily a permanent staff of INEC. It's one of the university professors or vice chancellor that they had asked to preside as a returning officer in Imo State. I believe, in the light of the findings of the Supreme Court, there must be consequential actions. That now that it has been established that the professor went out of bound of reason and indulged in this reckless pronouncement that has led us to this situation that we are in. He cannot be enjoyed the comfort of his home while he accepts to create or lay foundation that all kinds of political vultures are trying to feast on.
By INEC as required by law. 4. Did Hope Uzodinma call the 388 witnesses from the 388 polling units to speak to the result to obviate the principle of dumping which the Supreme Court had used against the PDP and our candidates, Atiku Abubakar, in the last presidential appeal? 5. Where the presiding officers and all party agents of the 388 polling units called to testify by Uzodinma APC, who were the petitioners. 6. What are the figures from each of these various 388 polling units generated and allocated to Hope Uzodinma APC by the Supreme Court? 7. Is the Supreme Court saying that all the votes from the alleged 388 polling units were for the APC alone in an election that was contested by over 70 candidates? 8.
My comrades, you do not have to be a practicing politician to know that there is usually, for the average politician, your own base is usually where you have the strongest support. Senator Hope is from the Olu senatorial zone, and it is the votes in these units that were not counted or collated for him, and they were never cancelled. So it was clear to us that even the first election petition tribunal, on the basis of this fact, would have no difficulties, first in nullifying Emeka's purported declaration as a governor because he didn't have the spread. This is a constitutional provision for which the court has no jurisdiction, sorry, has no discretion. Number 2, that there is no question that the votes in 388 units validly cast, signed by unit presiding officers, signed by party agents, were not collated by the collating officers. We had expected that the tribunal would naturally take this into account and Hope Uzodinma would have been declared. Because once you add the result from 388 units to the ones already accredited to Hope Uzodinma, he would have been the highest, he would have scored the highest number of votes ahead of all the other candidates. But by simply not counting these votes, that is why some people who are not informed keep insisting that the man INEC declared as last, as fourth, how could he come first?
Total accredited votes, 823,743. Total valid votes, 739,485 votes. Cancelled votes, 25,130. Total valid votes, 714,355. But at the Supreme Court, the total valid vote have increased to 950,952. And this can be cross-checked. This accounts for 127,209 votes in excess of a total accredited votes of 823,743. The question again is, can the Supreme Court sit in Abuja on January 15, 2020 to increase the total number of accredited votes in the election held in IMO on March 9, 2019? Is there any law which permits the Supreme Court or anyone else, for that matter, to unilaterally increase the total accredited votes by any margin after the accreditation and or the election? 9. Where did the Supreme Court get the numbers to declare Hope Uzodinma APC from a paltry 96,456 votes over Ihedioha PDP votes of 276,404. Even if all the excess accredited votes of 127,209 manufactured by the Supreme Court were added to Uzodinma APC, it will be still 223,657, still less than Ihedioha's vote of 276,494.
As I said, you are at liberty, because these are not classified documents, because every political party has a right, and they do usually exercise that right, and in this case that right was exercised to inspect the election materials. Neither the Emeka Ihedioha's lawyer nor PDP lawyer questioned the validity of the votes that were casted in these 388 units. They did not fault it because they couldn't fault it, because they were duly signed not only by APC agents, they were signed by the unit presiding officers as required by law, as well as agents of other political parties, including the PDP. However, because PDP has a reputation for manipulating systems, to our shock, the lower court, the lower tribunal, conveniently overlooked these 388 votes, 388 units, and proceeded to deal with only the other units. It made no comment. It did not nullify these units. Nobody had nullified those units. Nothing in the argument of PDP attempted to nullify those units. They just felt it was convenient to ignore the fact that these units were not collated. At the Court of Appeal, our lawyers again amplified that this is at the heart of our petition, namely that the votes casted in 388 units were not collated, and that Emeka Ihedioha did not have the spread required by law. Again, to our shock, the Court of Appeal judges that had that case, I'm not going to speculate, but there were all kinds of stories about what they had agreed at the first time and how they changed it at the second time, who put pressure on them. This will remain in the realm of speculation. But suffice to say that one of the panelists at the level of the Court of Appeal wrote a dissenting judgment. And in that dissenting judgment, it accommodated these votes in 388 units, and also found, as a matter of fact and in law, that Emeka Ihedioha did not have the spread and therefore could never have been declared as a governor.
2019, namely governorship and the House of Assembly. As already known, there was only one accreditation for the two elections. The APC did not win any of the 27 seats in the IMO State House of Assembly, which were won as follows. PDP won 13 seats. AA won 8. ABDA won 6. APC 0. Total 27. The above further question and confront the rationale for the judgment of the Supreme Court on Imo State. How then did the Supreme Court arrive at its decision to allocate results to void a lawful governorship election and impose an unelected person as a governor? The fact is that the Supreme Court, as presently constituted under Justice Tanko, has lost its credibility and no longer commands the respect and confidence of Nigerians.
But I was baffled when yesterday, because PDP has lost a state they never won, that the Supreme Court has, in their supreme wisdom, re-established the fact that these 388 units are part and parcel of Imo State, and therefore they cannot, the vote they have casted, which were never cancelled, cannot be wished away. And they have accordingly added them, and then found that Hope Uzodinma is not only the highest vote scorer, he had the required spread necessary to be declared the winner of that election. And the Supreme Court has so upheld. And Hope has since resumed duties in Owerri, in Imo State, as the governor of that great state. We commend the courage of the Supreme Court, and we condemn in the strongest term possible the attempt by Secondus and his party, the PDP, to try to personalize a panel of eminent jurists, all 7 of them, in their unanimous judgment, we are clear that this is the position of the law and these are the facts. For PDP and Secondus to call for the resignation of the Chief Justice of Nigeria because they have lost a state that was never there, that they never won, is the height of recklessness. And I want to appeal to them that they should not behave like the proverbial English turkey that wanted the Christmas to come a little earlier. Because on Christmas Day, every English family will slaughter a turkey. When they make statements such as, this is a coup, this is a threat to our democracy, they behave as if they have another passport. For the rest of us who have only one passport, the green passport, this democracy has come to stay. We all must contribute our quota to strengthening it and obeying the rules of the game. It is now a fact of history that PDP tried to deepen the culture of do-or-die politics, as pronounced severally by a president elected on their platform. It is a fact that PDP is a beneficiary of electoral fraud year in, year out, and over time it became part of their sing-song that rig them out and let them go to court. Many Nigerians of my age has not forgotten how PDP retained the presidency of Nigeria in an election in which the ballot papers used did not even have serial numbers. And majority of the Supreme Court judges felt that, even as we all know that when you go to a petrol station and fill your tank and you ask for receipt, that receipt must necessarily carry serial number for basic accounting purposes. The Supreme Court at that time, overwhelmed by PDP rigging machine and their determination to even convert angels to devils, persuaded our Supreme Court to accept that election. We brought Shehu Yaradua into office. And I'm happy that Yaradua admitted that even though he was a beneficiary of that fraud, but that is a fraud that must be corrected. PDP as a party can never, whether on ground of morality or on account of their known history, pronounce in the manner that they do, as if they are not the one that lay foundations for all the challenges we are continuously facing in our democracy. The current Electoral Act was not crafted by APC government. The current Electoral Act as it is was crafted by PDP government because they had the instrument of rigging, and they made it such a law that it is almost impossible for anyone who has been rigged out to seek redress from law court.